Good morning. It's my privilege to extend a warm welcome to teachers and students from Apex Friendship Middle School. Welcome. Thank you for joining us in the courtroom today, and we so appreciate your being here. Our state constitution reminds us that a frequent recurrence to fundamental principles is absolutely necessary for the continuation of the blessings of liberty. Uh, what you're doing today, just going through the process of learning more about our judicial branch and certainly our court system in North Carolina is very commendable. Thanks for being with us. I will call our next case, which is White versus North Carolina Department of Health and Human Services, and we will hear from the appellant.
Good morning, Chief Justice Newby and Associate Justices. May it please the court, my name is Tiffany Massey and I represent Mr. and Mrs. White, who are the petitioners, appellants in this matter, as well as the adoptive parents of CW. I would like to reserve 5 minutes for my rebuttal. First, I want to emphasize the opportunity that this court has to provide guidance to the Court of Appeals regarding respondents' duties to the children in their care. The Court of Appeals majority's decision is completely contrary to the legislative intent of the Adoption Assistance and Child Welfare Act of 1980, as well as this court's precedent that the best interest of the child is the polar star to which all considerations must yield. The Court of Appeals majority's decision functions to reward respondents' non-disclosure at the expense of CW and every other child whose future is now uncertain because respondents failed to adequately prepare his parents for the special needs that were foreshadowed both at birth and the time of the adoption. To begin, our main contention is that the Court of Appeals majority engaged in impermissible fact-finding on issues solely reserved for the Superior Court.
Can you help me understand what were the special needs that were evident at birth and then at the time of the adoption?
Yes. When he was born addicted to substances such as methamphetamine, opiates, and marijuana. He was born premature at 34 weeks and had to spend the first 2 weeks of his life in the NICU. And I believe he also had eye issues such as ptosis. I'm going to butcher those words, so I apologize. And then a couple other disorders that I highlighted in my brief. And then as he got older, he was diagnosed with autism, ADHD, and I believe a neurobehavioral disorder.
The diagnoses that you've indicated toward the end, were these evident at the time of the adoption, or these are things that have arisen subsequent to the adoption?
These are things that have arisen subsequent to the adoption. However, if you look at Dr. Centurius's records that are in the record, he talks about how all of those things stem from CW being born addicted to substances. So we would contend that those were very much foreshadowed because of the circumstances in which he was born.
Is there any way when a special need arises, such as in this case, for the assistance to still be available, or is it a snapshot at birth or adoption, and any needs after that are just on the adoptive family and not to be available for assistance?
It's supposed to be that adoption assistance, if it was apparent at the time of the adoption, and there was a discussion, it's supposed to be that they can get adoption assistance later. The Child Welfare Manual, which the Department of Health and Human Services promulgated, talks about the exception to the quote-unquote adoption assistance rule, which is the rule that the adoption assistance agreement has to be signed and in effect as of the date of adoption. So that's the way it was supposed to be, and that's the way their manual reads. But the part that I don't I can't really understand is the fact that their own manual states one thing, but then they maintain throughout their first and second decisions and final decisions that there is no exception to this adoption assistance rule. And there's no way whatsoever for these parents to get assistance for a child that they should have known would have had special needs at birth and prior to the adoption, as well as after. And as I said before, our main contention is that the Court of Appeals engaged in impermissible fact-finding on issues solely reserved for the Superior Court. And the Court of Appeals makes it very clear that they very much disagreed with the trial court. However, that does not rise to the level of an abuse of discretion. And to begin, I want to explain kind of the statutory scheme which guides this case. Congress enacted the Adoption Assistance and Child Welfare Act to promote and incentivize the adoption of children with special needs. They tasked each state with developing their own plan as to how to implement this act, and specifically, North Carolina tasked the Department of Health and Human Services as the entity responsible for implementing this act and providing foster care and adoption services. The way the department chose to implement this plan was to partner with contracted, licensed private nonprofit agencies like CHS in order to implement this plan. And in 2014, when CW was adopted, they were in fact a contracted nonprofit agency. And when I spoke about the department's manual earlier, this is a manual that they laid out all of their responsibilities as well as the private nonprofits' responsibilities. And the way it kind of works in cases involving children with special needs is that, and as in what should have happened in CW's case, the private nonprofit CHS should have sent a referral to the local county agency and said, hey, we believe he needs to be evaluated. They did that with Medicaid because it's undisputed that he received Medicaid from shortly after birth until shortly after his adoption. They did that with Medicaid, but it's also undisputed that there was no discussion whatsoever about adoption assistance from either of the respondents with my clients. The private agency sends the referral, and that kind of starts the process. However, the department is ultimately the one charged with making an eligibility.
Can I go back on when was you said CHS should have told the agencies that he needed to be examined or evaluated. Mm-hmm. Are you saying they needed to have done that earlier than they actually did in 2021?
So the conversation is supposed to happen prior to adoption. So like with Medicaid, he began receiving Medicaid in June of 2014. So whenever adoption became the plan, they should have had a conversation with my clients and explained what assistance may be available based on CW's needs. And that it's undisputed that did not happen in this case. And so at some point prior to the adoption, they were supposed to have that conversation.
Does the record help us because I was looking for some of this, where in the record we saw the interactions between the agencies? I mean, I know it's undisputed that he received Medicaid, so presumably someone signed off on that. But like, what I didn't see in the record is a real clear indicator of when the respondent agencies were actually understanding that this kid might need some more attention.
Yes. So I don't believe there's any mention of Medicaid in the correspondence that's in the record. And I'm not sure exactly why that is. And I use Medicaid as more of an example kind of to show the process of what should have happened. Um, but I don't believe there was any mention from them about Medicaid. However, I believe I mention it in their initial petition, as well as I mention it at the trial in the Superior Court. And the Judge Long also found it as part of a fact in his order, that part being they didn't challenge that portion of it, that he received Medicaid.
I've kind of a really high level question. And maybe this is so high level that it's becoming too abstract for this case. But if accept that you're correct, that the child was entitled to the adoption assistance, so that those facts are satisfied, and then you try to play out from here what might happen if we affirmed the Court of Appeals. It seems to me the record suggests that your clients just would not be financially able to care for that. Eventually the child would end back with social services. There'd be a process where eventually the parental rights that exist through the adoption would be terminated. The child would go through another process of foster care, trying to find potential adoptive parents. Those adoptive parents, if again you're correct that it would qualify for adoption assistance, when that adoption occurs, could timely request the assistance and would get it. In which case we've created this huge sort of circle of red tape and bureaucracy just to get back to using federal funds that are available to help make sure this child is cared for.
Exactly.
So it seems to me if we conclude you're right about criteria, the factual underlying criteria for the adoption assistance, there may be some path in equity here that we should be searching for that either comes from federal doctrine or it's part of our state doctrine that would allow that process not to have to work itself out. Mm-hmm. Can you help me see where that path is, though? Because I'm struggling. I can articulate it at an abstract level, but I'm having trouble seeing where the law would permit that.
Well, the thing is, it's already there. Their child welfare manual explicitly talks about if you believe you were wrongly denied adoption assistance based on a failure of the agency to have any discussion with you about assistance, you can go through the fair hearing process, which my clients did and which should have been enough to find CW eligible. But they have continuously maintained that there's no exceptions to the adoption assistance requirement. And now on appeal, they assert that he is ineligible for other reasons besides the fact that he had no adoption assistance agreement in place. And I will also add, if you look at the transcript of the Superior Court hearing, they all agree that if he were to be surrendered back to foster care and adopted again, he would receive financial assistance. And I think that's very telling when the Court of Appeals says that their decisions were justified. I don't know how you can argue that your decision was justified when it says in your own manual that there is this exception, and their final decision cites to the manual, but it completely ignores that exception. So that's our biggest argument as far as when the Court of Appeals says that their actions were justified. I don't see how they could be.
I'd like to ask a question. My understanding is that, and correct me if I'm wrong, DHHS and your friends on the other side make the argument that since he was adopted, then without the assistance, then there's no assistance because of that. But it seems to me if things have deteriorated to the point that he might have to go back into foster care, doesn't that undermine the fact that he was adoptable am I misunderstanding something? Because adoption is for a lifetime, or at least until the child's older. And so, yes, the paperwork happened, he was adopted, but if he sadly is returned back into the system, ultimately he wasn't adoptable. Am I missing something, or am I making an argument that's not being made? Or help me get my head around that.
I agree with you, and that's another issue that we have with the Court of Appeals opinion. They say, you know, there's no evidence to support the fact that he was unadoptable. However, the federal law and the policy statement clearly state that it's the child's needs, not the parent's needs, that you focus on. You can't look at whether the parents can afford it or not. Additionally, there is a very clear exception in that portion of the statute, and it's the first sentence. When it talks about that requirement, it says, except where it would not be in the child's best interest to shop around essentially for a family. And that's why we were very confused with this decision, because they ignored this very clear exception, which is very applicable in this case.
And where are you finding that? Which statute? You said it was a statute, I believe.
Yes, it's 42 U.S.C. 673, and it's if you look at little c, little c is the portion where it specifies the special needs, and then 1B, it states the state had first determined that there exists with respect to the child a specific factor or condition. And then if you go down to another B, and then it says that except where it would be against the best interests of the child because of such factors as the existence of significant emotional ties with prospective adoptive parents while in the care of such parents as a foster child, a reasonable but unsuccessful effort has been made. And the department's own child welfare manual explicitly states this. They explicitly state that you don't have to shop, quote unquote, shop around for a foster family. And there's ample evidence in the record to support that my clients were the only family that this child had ever known. So there, in no world would anyone have agreed that it would not have been in his best interest to stay with my clients. And that there was no need for anyone to look around, because it would not have been in his best interest.
So is there a duty to inform prospective adoptive parents of the special needs?
Yes, and case law from other jurisdictions reinforces that affirmative duty. It's, I believe, first talked about in the U.S. policy statement, but case law from our other jurisdictions interprets that to find an affirmative duty. The first kind of line of cases of that was the Ferdinand case, which is very applicable to this case, because my friends on the other side consistently maintained that because he was adopted from a private nonprofit, that somehow disqualifies him from receiving adoption assistance, when that's very clearly not true, because the U.S. District Court of Rhode Island in Ferdinand found that the department in Rhode Island owed an affirmative duty to the child's adoptive parents to tell her about adoption assistance. And actually in that case, there was, I think they describe it as a de minimis there was some conversation. Here, there was no conversation whatsoever, and that's undisputed in several, it says that in several parts of the record.
And there's also a duty to inform about the ability or means to defray costs associated with these special needs. Where do we find that in the record? Let me, is there a duty to inform your clients that there may be adoption assistance or an ability to defray cost?
It's our contention that there was, because CW received Medicaid. That is the connection that we argue connects them to the department. My friends on the other side cite Laird to support their argument that because there was no real connection between CW and the department, that disqualifies him. However, he received Medicaid. The department had to evaluate him, make the ultimate eligibility decision, and ultimately find him eligible for Medicaid, which they did, and which is undisputed.
Is that based solely on special needs?
That is part of it. There's also, I believe, a financial aspect of it, and I don't know the exact requirements for Medicaid. I'm happy to do further research on those, but I also believe the financial portion also goes to one of the other eligibility requirements that the Court of Appeals talks about is pertaining to that he didn't receive a foster care maintenance payment, and that kind of correlates to the aid to families with dependent children. There's a financial aspect to eligibility, which, as you in the record, it's one of the some of the medical records references the fact that CW's birth mother had 2 other children, was receiving WIC benefits, and was unemployed. So we would contend that Judge Long properly found that portion of the eligibility requirement that the Court of Appeals says, there is no evidence of, there's very clearly evidence in the record that says that.
If there is a requirement that adoption assistance information be shared with prospective adoptive parents, where could we find that in the record to show that it occurred here?
The evidence for that is in Judge Long's findings. The North Carolina has not necessarily addressed that. However, I do believe it's kind of alluded to in the department's manual, because they reiterate that it is their responsibility to promote the adoption assistance program.
No, I understand, but other than the manual, where in the record could we find that information was conveyed to your clients?
That what information was conveyed?
About the adoption assistance, that the department or someone acting at their behest informed your clients about the adoption assistance program.
You can't find it because there was no discussion. There was no discussion whatsoever about adoption assistance, and so that there's nothing in the record to show that.
Is the mere fact that a child is born perhaps cocaine dependent or with controlled substances in their system, is that alone enough for a finding of special needs?
No. However, I would argue that one of the requirements is that the child have a specific medical condition that affects his daily life. There's also another category that specifically says, or he or she is at risk for developing such a condition, and that would certainly meet that qualification. As I said before, if you look at Dr. Centurius's records, he specifically says that correlates to the disorders that CW has currently.
Why wouldn't that apply to every child then? Every child that's born cocaine dependent or who tests positive for controlled substances, why wouldn't that condition be likely to occur in the future for all children in that class?
It could. The child would have to meet all the other requirements, but it's our contention that it would apply because you can show that he's at risk for such a condition based upon being born addicted to substances. And if I wanted to mention another case, the Jamison case out of West Virginia. It is also very applicable because the child in that case was adopted from, it was a private adoption. He was only in the department's care for, I believe, 10 days. And the court returned the child to family members, the adoptive parents, and the way the court found in favor of the adoptive parents was through the Medicaid connection. The child received Medicaid from the time that he came into care until adoption, and that's how the court connected the child to the department. And all of these cases, all of the cases that I've cited in my brief, they go to great lengths to find in favor of the adoptive parents, because there was no discussion between the department and the adoptive parents. And they also explicitly state that parents should not be allowed to waive adoption assistance for their children without full information and knowledge of all possible benefits, present and future. So all of these different courts clearly place the responsibility on the department rather than my clients. And unless there are any further questions, I'm going to reserve the rest of my time for my rebuttal.
Thank you, counsel. We'll hear from the appellee.
Thank you, Your Honors. And may it please the court, my name is Adrian Dellinger. I am an Assistant Attorney General with the North Carolina Department of Justice. I am here representing the North Carolina Department of Health and Human Services, the agency that issued the decision that is under appeal, the one that was reviewed by the Superior Court under 150B Article 4. Just on the outset, I'm going to spend about 20 minutes discussing the majority of the issues. I did want to reserve 10 minutes for counsel from Children's Home Society to discuss some of the issues that are relevant to them. So I will do my best at 20 minutes to sit down. But I just want to give the court that update. So this case involves the eligibility of an adoptive family for adoption assistance benefits. Adoption assistance benefits is a joint state and federal program where large amounts of money come from the federal government. That money comes pursuant to an agreement with the federal government, subject to both federal law, federal regulation, and of course state implementing law and regulation. The benefit is intended to provide assistance and, most importantly, incentives to prospective parents to adopt difficult-to-place children. In a 2-to-1 opinion, the Court of Appeals held that petitioners, as the child's adoptive parents, did not meet all of the eligibility criteria, and because of that, they upheld the Department of Health and Human Services decision to deny those benefits. We ask that you uphold that Court of Appeals opinion. The majority opinion lays out in detail the state and federal eligibility requirements, probably better than I did in my brief, and methodically applies those requirements to the petitioner's case. The majority opinion is well-reasoned, supported by the record, and correctly applies the law.
So can you respond to my question I asked your friend, which is, let's put aside the factual questions about child's special needs and assume that it could be proven factually that the child would meet that criteria. If somehow we could snap our fingers and either set aside the adoption or terminate parental rights, the child is back to CHS, and we have a do-over where the parents say going into it, we need to get the assistance and we have the agreement to do that. In your view, what would happen?
Well, there's a couple of things. Number one, most likely the child would not be in CHS's custody. They would most likely, if the parents abandoned the child, that child would end up in DSS custody, not CHS. If they were, worked with an adoption agency to try to do a private adoption, there would certainly, that's a potential. So one of the important things to know here is that,
And you think that matters because there is a difference between the private adoption agency in terms of the eligibility and the, yeah.
and one of the things, and this is something that I had the most difficulty in sort of understanding as I went through the federal regulations and the state regulations, is there actually is this long period of time where there's been a transition. And in fact, in the old system, as you look through the federal statute, there was a time when it was only state adoptions. If they were in North Carolina, that would be a DSS, a custody adoption. They were turned over to the state, parental rights were terminated. It had to go through that. Or the child had to be eligible for SSI, and that's, of course, a very high bar. What the federal government does, what the U.S. Congress has done, is they've actually created this sort of tiered system, and they're sort of slowly bringing more and more children in. And that's where you get this definition of eligible child or ineligible child. And so in this particular case, in 2014, when the child was adopted, when the child was 6 months old, under the federal regulation, he was an ineligible child. Because of that, he fell under the old system. If he was adopted today at his particular age that he is now, he would be an eligible child, so he would fall under the new criteria. Let's pretend, or let's just say that he was born today instead of in 2014. He actually would, I believe, would qualify because the eligible child category has now encompassed every child that was born or is 0 years of age in this federal fiscal year. And to really, if I may, to point you back to the federal statute, and this is all in 670, this is in 672, and the determination of eligible child or ineligible child. Excuse me, I'm so sorry. Oh, it's in. Here we go. My page is stuck together. This is in subsection E. There's an age, and it looks like for the case of fiscal year 2010, the applicable age is 16 or over. So in 2014, the applicable age was 8 or over. And so for a child who was 8 in 2014.
So you're talking about 673, not 672.
Let's see. I think you are correct. Yes, 673. I misread that. I'm so sorry. But yes, if the child had been 8 in 2014, had problems that would have made them a special needs child, it's possible that they could have been eligible. The issue, one of the issues, the big issue here is that at that time, the federal statute had this distinction between eligible child and ineligible child. The child here, CW, fell into that category of an ineligible child and therefore fell into the old determination, which required that they either be receiving federal foster care assistance or foster care maintenance payments or supplements or eligible for supplemental security income, SSI. That's a very narrow range. And of course, with that definition, you're looking at children who are in DSS custody, that are placed with a foster family, that are receiving these foster care benefits, and then are adopted out of that state foster care.
So is there a way, I mean, I know you probably see where I'm going with this line of questioning, but is there, if we agree with your interpretation of the interplay of these regulatory provisions, is there some way under state law or in equity that we can speed up the process of allowing like some sort of do-over adoption so that these parents could try to get the adoption assistance in a new adoption meeting all the eligibility criteria, because it seems to me without that, there's little chance that these parents would be able to have any hope of adopting a child in the future if they were to lose custody. And it just seems like that is not serving the purpose of these laws.
So the first thing I would say is that the eligibility factors always seem a bit arbitrary. They are determined by the U.S. Congress, by the Federal Department of Health and Human Services, and by our General Assembly. And so what those eligibility factors are, what those criteria are set by folks other than the department. We are just doing our best to review those eligibility criteria and apply them correctly. To your point, the petitioners in this case, the only way that the child could be readopted is if there was a termination of parental rights, and there would be no way that they would be able to readopt a child. I have a 16 going on 17-year-old son. There are certainly times as a teenager I would love to say you should be somebody else's problem. But if I were to do that, he would become Wake County DSS's problem. I would have no further interaction or relationship with him. And I would never be the beneficiary of any benefits he may be eligible for because he was abandoned by his family. And so I think that's the key here, is that yes, they are in a situation where they were ineligible to begin with, but that's also the petitioners, the parents here, would never be eligible. If they adopted a child now, maybe in that situation where you have parents, where you have a new child, there may be something. But under the facts that we have, under the statutory and regulatory framework that we have, they were not eligible. And so just as I am not eligible, and so to sort of push back on the sort of, is there an equitable relief here? This is an administrative appeal. This is an appeal from the decision of the Department of Health and Human Services, a decision that they made up through the Superior Court and the appellate courts through Chapter 150B, the Administrative Procedure Act. More importantly, the Article 4, which discusses judicial review. This is not just a civil action. This is not something where they can sue for equitable relief, something where they can sue for damages, something where they can, get anything other than a reversal of the agency's decision and the potential for attorney's fees if the agency has acted arbitrarily, capriciously. And so, first and foremost, I will not sit here and say that the Supreme Court doesn't have equitable power, but I would argue that in this instance, under this jurisdiction, this subject matter jurisdiction, equitable relief is not appropriate. The relief that is appropriate here is to look at the agency's decision, determine whether or not it has been done, whether or not it was correct based on the law.
I have a question about what the COA decision does to our law. Does it, in your reading, does it specifically adopt the extenuating circumstances doctrine?
No, and I read it to reject it. There are the extenuating circumstances sort of came out of policy guidance by the Federal Health and Human Services. Again, this is not a federal regulation. This is not a federal law. This isn't even something that was passed by the General Assembly. This is a policy guidance document given by federal HHS at the time, and it has been interpreted by some courts to provide this extenuating circumstances. The issue here, well, first and foremost, we've never had an we've never adopted the extenuating circumstances. Further, the cases that the petitioners cite that relate to extenuating circumstances are significantly different than the facts that we have here.
Well, just to go back to my question, though, it seemed to me what the COA was saying was we've never adopted it, but even if we had, it wouldn't fit these facts. Am I wrong? You seem to be reading it as expressly rejecting it. Explain to, if I'm wrong, explain to me why I'm wrong.
I don't think I'll say that you're wrong. Your reading is probably a bit more nuanced than what I just said, and correct. I think the way I look at it is you're correct. The court did not need to reach the extenuating circumstances. I mean, they say that there's no court we have not adopted it in North Carolina. They don't really issue a decision on whether we should or should not. But I think their review of this particular case is that not only would extenuating circumstances not be necessary, well, because extenuating circumstances would not be necessary because there were other eligibility factors. And so there's that's kind of the two questions that I think that this court has to answer. You know,
Am I
first,
understanding correctly, the extenuated circumstances, what is that an exception to? Is it just to the requirement to have the agreement?
yes.
Or so the fact that this is a private adoption agency that may not, if you kind of track through, I guess it's like 672, 73, 74, and piece it together, that you couldn't use extenuating circumstances to excuse the fact that you weren't entitled to the agency wouldn't have been able to receive the proper payments. Is that your argument?
Correct. So, the best way to look at it is if the only issue here was whether or not they did or did not have an adoption assistance agreement in place prior to the adoption, I would be up here making much different arguments. I would be bringing up much different facts and provisions of law. It is not just that they did not have an agreement in place prior to the adoption. While it wasn't very clear in the different hearing decisions, while that did seem to be the majority sort of issue that most of the administrative hearing officers decided on, there are other elements that they do not meet. There are other eligibility criteria that the petitioners and CW just did not meet. And so even if we go back, we get in a time machine and go back to 2014, and we tell them, hey, go ahead and apply for adoption assistance benefits, they still would have been rejected. Not because they failed to have an agreement in time, but because this was a private adoption through a private adoption agency where there was no interaction with the state, where there was no interaction with state or county officials, and where the child and the family were not receiving either foster care maintenance payments, nor was the child at the time eligible for SSI.
So really then it doesn't matter whether we have the extenuating circumstances doctrine or not, in your view?
Yes, correct. And so this case certainly does not need to be decided on that, just as the Court of Appeals did not review our jurisdictional arguments or any of the issues related to attorney's fees, because they were able to look at all of those eligibility factors and say this child just was categorically ineligible. So do you. I do not believe that this court needs to review whether or not extenuating circumstances should or should not have been in play here. The question.
Your friend on the other side makes a big deal about the Medicaid issue and that's the connection. Could you help us understand your position in that regard? Because you just said there was no connection, but she's arguing vehemently that there is.
Yes. So Medicaid eligibility is, of course, handled by the counties. In this particular case, the eligibility for his Medicaid, the application was submitted to Guilford County, whereas the adoption went through in Forsyth County. So there's nothing to indicate that Forsyth County was in any way, shape, or form aware. Even if the application had been made through Forsyth County, there are plenty of confidentiality provisions and other such provisions that would prevent eligibility caseworkers from sharing information with caseworkers in child welfare or adoption that may be involved in that application process. That is the only connection that petitioners can point to, only real connection. Petitioners do argue that for some reason Children's Home Society has a contract with the HHS that's not supported by the record, and it's not relevant to create some relationship between CHS and the HHS as it relates to like the Title IV-E foster care or Title IV-E adoption assistance benefits. And I won't go through every single case that they cite. I do think it's important, though, to point out that in all of them, and certainly Jameson, Kimmel, and Ferdinand, there was a direct connection with the state agency in charge of child welfare. In Jameson, the state was granted emergency custody I believe at the time of the child's birth. The state, not a private adoption agency. The state was granted emergency custody. In Kimmel, the child was placed in state care and custody. In Ferdinand, the facts are clear that the child was adopted from both the State Department in that state and the private adoption agency. The facts are clear that this sort of this joint system. We don't have that in this case where we have a contractor helping us handle these state adoptions. This is a totally private adoption. And in our state, we have county DSS caseworkers who do that work, not generally private contract adoption agencies.
Does the department have any obligation or legal duty to inform a private adoption agency that a child is born cocaine dependent or tested positive for controlled substances?
Would the state have any reason?
State have any, or the department?
I'm not sure how the state would be made, how the Department of Health and Human Services Division of, I believe it's Division of Child and Family Wellbeing, I'm not sure how they would be made aware of that. As it relates to adoption, I'm not sure how they would be aware of that as part of a private adoption. And again, so if they were notified, hey, this, you have somebody who's about to give birth who has prenatal exposure and there's some concern for the health, safety, or welfare of the child, then the Department of Social Services Child Welfare would get involved, and that would be your connection. That would be your nexus. That would be very similar to the case like in Jameson, where that state agency was given emergency custody. I mean, they almost immediately turned the child over to some private adoption agency, but that's not what we have here. The state was in no way, shape, or form involved. And so it's just, for that reason, it's just not it's not relevant. No. Unless there are any other questions, I was going to give the rest of my time to counsel from Children's Home Society. Thank you, Your Honors.
May it please the court. Good morning, Your Honors. My name is Michelle Smith with the law firm of Hill Evans, Jordan & Beatty in Greensboro. We represent the Children's Home Society of North Carolina, which is a private, nonprofit child placing agency, and we're one of the 3 respondent appellees in this case. I'd like to address a narrow issue in this case that affects both my client, Children's Home Society, as well as respondent appellee Forsyth County DSS, represented by Teresa Boucher with the Forsyth County Attorney's Office. And that's the issue of whether the Forsyth County Superior Court, in hearing Mr. and Mrs. White's petition for discretionary review, had subject matter jurisdiction to order Children's Home Society and Forsyth County DSS to approve CW for adoption assistance and to pay the White's attorney's fees associated with their petition. Because the Court of Appeals reversed the Superior Court's order reversing the final decision of the North Carolina Department of Health and Human Services, the court elected not to address the subject matter jurisdictional issue. And just briefly, I'd like to say that under Chapter 108A, North Carolina law is clear that it's the North Carolina Department of Health and Human Services that had the ultimate decision-making authority to determine eligibility for adoption assistance. And in addition, the Whites' petition for discretionary review was limited by statute to a review of the final decision of that state department. Neither Children's Home Society nor the Forsyth County Department of Social Services had the ability to make this decision or the authority to make the decision. The final decision denying adoption assistance was made solely by the North Carolina Department of Health and Human Services.
I think there's an allegation that Children's Home Society did not inform the Whites of the availability, potential availability of any adoption assistance funds. Is that correct? And was there such a duty to inform?
So the record does not contain any evidence, Justice Newby, of any interaction between the Children's Home Society and the adoptive parents. That information wasn't included by the adoptive parents in their process of pursuing adoption assistance. Children's Home Society wasn't involved at any stage in that process. They weren't involved in any of the appellate processes. They weren't involved in the final decision. We weren't in a position to present evidence to the contrary. So all I can say is that there's no evidence in the record that issue was or was not discussed other than the adoptive parents' statement.
Was there potential availability to the Whites at the time the child was born?
So the situation was, as Mr. Dellinger explained, back in 2014, a private agency's access to refer parents for adoption assistance was very limited. I mean, until recently, a child placed for adoption with a private agency in North Carolina wasn't eligible for adoption assistance unless that child was determined to be eligible for supplemental security income, SSI. And to be eligible for SSI, the child would have had mental and physical impairments, the results of which were so marked and so severe that there were grave functional limitations and that it would be expected to result in death. I mean, that's how the SSI rules were written. And so it was, this was not a child whose medical and physical condition at the time of his birth was such that the agency could make a referral for supplemental security income, and that is in the record.
Can I just ask, sorry, just going back to your immediately prior answer, I'm just curious about the order from Forsyth County District Court, which finding of fact 10 says all parties stipulate that no discussion was had with petitioners regarding the potential availability of adoption assistance prior to CW's adoption. As a result, no application for adoption assistance was submitted prior to the adoption. So are you saying that there wasn't a stipulation?
I'm saying that finding of fact is inaccurate because there was no such stipulation. And in our briefing, we addressed that. If you look at the transcript of the hearing, there was no such stipulation. There's no such stipulation in any pleading by the respondent, Appellees. There's so many things in this case that are sort of half-truths, and so I feel a need to sort of to go back to say that when reference has been made about adoption assistance and what the program was designed to provide for initially, and certainly in 2014 when this child was born, everybody's leaving out these key words. It's is to promote the adoption of children with special needs in the custody of a state agency. And Children's Home Society is not a Title IV agency. We do have some contracts with the state now where we license families to be foster families so that DSS has a place where they can place children in a home, children who are in their care, that are in their custody, into a safe, licensed home for care. But we've never had the opportunity to provide foster care, to determine adoption assistance. We don't have those powers. Those are state powers that are shared by the county DSS, no private agency has those kinds of powers. And in addition, let me just say very quickly, there's no evidence in the record that this child tested positive for any substances. There's evidence in the record that the mother tested positive for certain substances. Cocaine is never mentioned. Cocaine is never a part of any medical record that is part of this record. However, it keeps being repeated. It was in the order, it's repeated, it's in our brains, but it's not, there's no evidence in the record that that is true. There is, and in terms of the extenuating, I'm jumping all over, but in terms of the extenuating circumstance doctrine, all that doctrine does in states that follow the extenuating circumstances doctrine, or that did back when it was a part of a federal law, all it did was allow adoptive parents to have a fair hearing. It didn't confer eligibility for adoption assistance. And in fact, the ACF rule that is cited by both sides says specifically that. It says, and the Laird case that both sides refer to says this also. It says that that it's only available.
Counsel, I believe your time's expired.
I'm so sorry.
Thank you.
Thank you.
Rebuttal.
Thank you, Your Honors. I first want to address my friend on the other side's contention that there's no evidence saying that he was addicted to substances. If you look at every single evaluation that is in the record, it talks about how he was born addicted to substances such as methamphetamine, such as marijuana. All of those mention that. And so all of that is in the record. Additionally, as far as her contention about contracts with the department, if you look at the appendix to my brief for this court as well as for the Court of Appeals, I've attached audit reports from 2014 which clearly show that CHS received money as a contracted agency from the department. And I believe I also attach a screenshot of their website which advertises foster care services and advertises adoption care services. When my clients adopted CW, they were assigned an adoption social worker with CHS. Therefore, they essentially function the same as the Title IVE agency. They don't have the ability to make an eligibility determination. However, it's clearly stated in the Child Welfare Manual. There's a section titled Working with Private Agencies, and it outlines the process for what private agencies have to go through when they have children in their care who may qualify for adoption assistance. And it explicitly states that they have to send a referral to the department, and then the department makes that eligibility determination. And then as far as the kind of staying along those lines, I believe there's an issue here when it comes to North Carolina because of the way that they have decided to implement the plan. Private agencies, while they may not have eligibility determination ability, they still function as a Title IVE agency. They still issue Medicaid cards. They still start the process for a determination for adoption assistance. They function essentially the same way, and the federal law doesn't really distinguish between the two. There is in the first eligibility requirement, there's some distinction, but it doesn't apply in this case. CW still meets all of the eligibility criteria, which Judge Long details in his order. And I believe I'm almost out of time. The only other thing I would like to address was the department's assertion that CW was not eligible in 2014. If that were the case, then Ferdinand wouldn't have been decided the way it was. Jameson wouldn't have been decided the way it was. Kimmel wouldn't have been decided the way it was. In all of those cases, the child was either an infant or less than 2 years old. So if that were the case, then none of those cases would have held in the way that they did. And for all of those reasons and the reasons cited in our brief, we ask that you reverse the Court of Appeals decision.
Thank you. Mr. Clerk?
All right.